In Chapter 10, we're going to talk about the various types of privileged communication. So, privilege means that the content of some communication is protected from compelled testimony, and there's usually important sociological, societal reasons for that. So, when does it possibly arise? Well, when we have communications where we expect confidentiality, generally when there's special relationships between the parties. The communication is not revealed to others and might otherwise be admissible under some exception to the hearsay rule. So, the legal system operates on the basis that what we say can be used against us. But sometimes there are relationships in which we engage where it's necessary to keep communication private, and that outweighs the desire to find out the truth in court. But again, not all communication is protected. Once it is protected, in order to invoke this privilege, the right to remain silent itself. Once invoked, the right to remain silent should itself be protected. So in certain relationships, we have to have confidential, open communication. So think about marriage, right? In order for a marriage to function properly, we need to have open communication. And we need that communication to be confidential. So along with this comes the idea that the person who invokes privilege cannot be punished for doing so. And this privilege applies to both oral and written communications. In order to invoke privilege, it has to be confidential communication, and there has to be an appropriate relationship that establishes that privilege. In order then to show confidentiality, two people have excluded everyone else from the room while they talk, or they made an effort to not be overheard. So if you've invited a third party into the conversation, then it's not confidential and it's not privileged. Written materials that are stored so that no one else can see them also shows confidentiality, so they've delivered in a sealed envelope, or it's faxed with a cover letter stating it's confidential. So what are some problems here? The communication in question has to also be relevant, not hearsay, or if hearsay, under some exception. The communication, as I mentioned, that's covered is oral, written, digital, and even nonverbal acts. But the privilege can be waived by disclosure to another party. So there's some types of privilege that are not grounded in the idea that a close relationship requires confidential communication. That includes things like police personnel records, the identity of police informants, or sources that the media has used for a story. So in 1999, we have Mitchell v. United States. Mitchell is facing a sentencing hearing after he's been convicted of a crime. And at trial she pled guilty. The prosecution claimed the plea was a waiver of the Fifth Amendment. The Supreme Court disagreed, citing the case of Griffin v. California. The right to remain silent is almost absolute, and no inference can be attributed to it. So what are some commonly used privilege? At common law, there were very few, and legislatures have developed new ones over time. So attorney-client privilege, spousal privilege, doctor-patient privilege, clergy penitent, official information, and media privilege. So attorney-client privilege. This dates back to the 1600s and is established in common law. And what is the reason for this? Well, an attorney cannot properly handle your case and properly defend you without full disclosure of the facts. And that privilege includes an initial consultation, even if you decide not to hire that attorney after that consultation. Doesn't matter who pays for the attorney, and a payment isn't even required. The privilege belongs to the client. Okay, so the attorney can't waive privilege, only the client can waive it. And there's no privilege if the communication is made in furtherance of a future crime. So if you're chatting with your attorney about breaking the law in the future, that's not privileged information. The communication covered is only that of a legal nature, and only the attorney and the client can be involved in the conversation to be covered. Now, that does include staff members and expert witnesses, but if you bring your friend to the consultation, it's no longer considered privilege. Some states allow privilege to be pierced if future physical harm of an innocent party is possible, and this is one of the strongest privileges that exists. We talked about spousal privilege. At common law, one spouse was considered incompetent to testify against another, and the first modern statutes appear in 1850. Doesn't apply in all cases, but it does restrict testimony concerning conversations made during marriage. So if a crime, places where it doesn't apply, if the one spouse commits a crime against another spouse, if a crime is committed against your child, or in cases of bigamy or fraud in marriage. There's two types of spousal privilege. One is the communication between husband and wife. In order for this to apply, you have to be in a valid marriage. Half of states hold that the privilege continues after divorce or death. Many states include actions as well as words, so you saw your husband hiding burglary tools. Both husband and wife hold privilege to refuse to disclose, right? So you can say, I'm not going to disclose. You can also prevent your spouse from testifying. However, if your spouse discloses the same information to a third party, it's no longer considered privileged information. Because remember, it's no longer considered confidential at that point. It also applies when one spouse is called to testify against another. And this is because it damages a marital relationship. In order to invoke this, you have to show that you are married, and this privilege ends when the marriage ends. Who holds the privilege varies by state, so whether or not it's the person, the defendant, or the person testifying. Some states do not allow the privilege if the marriage occurred only to use the privilege. And privilege includes information from before the marriage actually occurred. What about doctor-patient privilege? This doesn't exist at common law, and first time we see it is in 1828 in New York law. And it's based on the need for a doctor to have a true and accurate information to treat a patient. Doctors today often, as part of their initial screening or when you come in for your yearly physical, will ask you questions about drug use. If that privilege didn't exist, you might be, reluctant to disclose to your doctor that you're using drugs. But whether or not you're using drugs is certainly impacting your health and information that your doctor needs. So this only exists if both parties make reasonable attempts to keep the information confidential. A nurse or someone taking notes, secretary taking notes, does not affect the privilege. And in some states, the presence of a close family member does not affect the privilege either. This is a limited privilege. Only some information is blocked. Basic identification from the patient is admissible. Your name, dates of appointments. And then, of course, any exams that your employer requires are not confidential. The whole purpose of that exam is to provide some information to a third party. So this could include drug testing, a blood test for a marriage license, exams for insurance, a court-ordered medical exam, an exam for an expert witness, gunshot wounds, fetal death, sexually transmitted infections, and autopsy. Autopsy isn't covered because privilege covers the living person. The privilege here belongs to the patient, and the doctor is expected to uphold it unless waived, and it continues after death. Services provided by a doctor that aids in the commission of a crime, however, is not privileged. And this privilege doesn't apply just to your medical doctor, but also to a psychiatrist and psychotherapist. What about clergy penitent privilege? This did not exist at common law, and each state created one, and it comes from the idea of the confidentiality of the confession. The court looks to the doctrine of a particular faith to determine who is covered. If the faith imposes the duty on the clergy to keep these communications secret, then generally the privilege exists legally. This covers confidential communication between clergy and penitent for spiritual purposes, and the privilege belongs to both the clergy and the penitent. It doesn't apply, though, if the clergy member is playing another role, like marriage counselor, or they're at a church picnic and they say bruises on you. And there are generally, in most states, exceptions for things that we consider to be mandatory reporter issues, so harm or neglect of a child. The First Amendment does not create a special media privilege. Only state law or case law can do that, and 31 states have some form by statute, and 25 in total have some case law protection. There's a great deal of variation here on what is and is not protected. In the 1978 case, Searcher v. Stanford Daily, the police wanted access to photos taken by the student paper at Stanford University. The police obtained warrants, and the paper sued, claiming the media had privilege under the First and Fourth Amendments. The Supreme Court upheld the warrants. Later, Congress then passed specific legislation to protect these papers from such searches. Reporters often feel an ethical obligation to keep some sources confidential. Courts recognize, though, that this is a limited privilege, and courts can compel a reporter to divulge the source under threat of contempt of court. What about executive privilege? Well, there is a claim that the president need not disclose confidential communications, and this was first claimed by our first president, George Washington. This, however, is considered a limited privilege. In order to pierce it, it needs to be a confidential communication needed for a criminal or civil matter. The statement has to be requested under subpoena, and generally there's going to be an in-camera proceeding to weigh the merits of piercing that privilege. So in U.S. v. Nixon from 1974, during Watergate, Nixon claimed that executive privilege was absolute. He did not want to turn over the Nixon tapes. The Supreme Court recognized this privilege as necessary, but put some limits on it. It said the privilege, quote, must yield to the demonstrated specific need for evidence in a pending criminal trial. What about official information? Common law provided a privilege if disclosure of those documents would be against the public interest, and this generally applies to military and diplomatic secrets. The public has a limited right to access information held by the government, especially when it has to do with national security. It is often available under statute, and often we see these documents get requested as a FOIA request, the Freedom of Information Act. But you cannot request this if something's still an ongoing investigation. There is a limited privilege for the identity of informants. It applies only if the police have made representations of confidentiality to that informant. Their identity may be disclosed if necessary for a defense, but not just when probable cause is determined. So in 1967, we have McCrary v. Illinois. McCrary was arrested without a warrant by Chicago police officers based on information from a confidential informant. At a probable cause hearing, the defense sought the identity of the informant. The Supreme Court said the government does not have to disclose it during a probable cause hearing. However, that could be different at trial. And generally, if you want testimony introduced by that informant or information that informant found and you don't have another way to introduce it, then at that point you either need to produce the informant or you need to not use it in court. It's generally how that's treated. The decision to pierce this is decided in an in-camera proceeding. The Supreme Court has upheld that there is a right to obtain the name of an informant if it is crucial to the case. If the informant provided information, but police investigated and developed the case, you might not have to have the informant testify. The police may refuse, but generally then the charges will be dismissed. This also covers records held by the police. So police personnel files are generally privileged unless there's litigation. Sometimes there is relevant information in there that an officer committed perjury or an assault and battery where an officer claimed self-defense. In those cases, the defense would file a motion for discovery. If the police department refused to turn it over, then the judge will hold an in-camera hearing to determine if anything in there is actually relevant. And that wraps up privileged communication.